office.
Yes, Mr. Goodman.
My Lords, I appear for the 4 appellants in this court in the matter of ASY and others against Secretary of State for the Home Department. These appellants were claimants in the county court, respondents in the High Court. So to avoid confusion, I'm going to call them claimants.
Yes, much the best.
And likewise, for the respondent, I shall refer to the respondent as defendant. I am instructed by Dayton Pearce Glynn. I appear with Mr. Amunwa. My own friends, Mr. Toman and Mr. Tarbury, appear for the defendant instructed by the Government Legal Department. The court should have an authorities bundle in 3 volumes, a core bundle, a supplementary bundle, and a skeleton argument from each party, and then a supplementary skeleton responding to the cross appeal from the claimant.
Yes.
Grateful. The claimants in this matter appeal against the judgment and order of Mrs. Justice May, who I shall refer to as the judge, the Home Office against ASY and others 2023, EWHC 196. The judgment allowed the appeal of the defendant against the County Court judgment of His Honour Judge Walton in favour of the claimants following a trial of a preliminary issue. The claimants are a number of single mothers, each of whom has limited leave to remain in the UK with at least 1 British child, each of them earning minimum wage as key workers. And in each case, the defendant, as an exercise of a discretionary executive power, imposed on each of them a condition that they should not have recourse to public funds, NRPF, no recourse to public funds conditions, pursuant to an immigration rule and an instruction which was considered and held to have been unlawful by the Divisional Court in the case of W. My Lord, I'll just give a very brief overview of where my submissions are going in summary, and then I'll give some headings before I get into the meat of it all. The preliminary issue which the County Court was tasked with determining was whether the claimants could claim damages under Section 8 of the Human Rights Act 1998 in respect of breaches of duty under Section 6 of the Human Rights Act by the defendant, which did not in themselves entail imposing inhuman and degrading treatment, but were rather of a procedural character.
Well, now, you have reworded the preliminary issue. I think it's expressed rather differently in the actual order, isn't it?
In the order, it's put in terms of procedural rights rather than a duty under Section 6. That's the distinction between the way in which I've articulated it, but it's a distinction of form, as I'll come to show, because the only entitlement to damages under Section 8 is in respect of a breach of a Section 6 duty, and the Section 6 duty is not to act incompatibly with a convention right. So in a sense, it's a different way of formulating it. The way I put it now is perhaps slightly more accurate, but it's a difference of form rather than substance.
I'm puzzled, speaking for myself, at the way this was handled in the county court. I would entirely have understood if there had been an order for the trial of liability before quantum, of course. That's very sensible. But the way the order was expressed, page 337, paragraph 5. Work out whether that was a sort of moot question to be decided on assumed facts, or whether it was in truth a disguised trial of liability.
I understand the difficulty at this remove from understanding that. I can explain that in detail. I can do it straight away if that would help.
Yes.
It wasn't quite how I was going to do it in my planned order, but I'm happy to do so. So the way to understand it is to start with the pleadings,
Yes.
which the particulars of claim are in the core bundle at 367.
Sorry, which page?
Core bundle 367, my lord. So my lords will see that this was titled a generic particulars of claim in respect of 5 claimants, as it was before the county court at the time of pleading it. These 5 were, in a sense, the first to go forward. In the schedule is set out that there are a number of other claimants at different stages in the process, totaling 94 in fact. Some of them stayed, some of them pre-action and so on. The starting with
So sorry, this is generic particulars for 94 claimants.
well, it's for these 5 claimants, but it's seeking. So these are the generic issues for these 5 claims. Let's not complicate it with the others.
Yes.
So these claimants brought their claims both on discrimination grounds and Article 3 grounds, seeking damages under the Human Rights Act and under the Equality Act. Paragraph Part 4 of the particulars on page 371 and Part 5 are the Equality Act and Article 14 claims. We're not concerned with those aspects of the claim.
Okay.
They haven't been progressed thus far. Then paragraph 2 on page 368 sets out some of the generic background facts which my lords will have become familiar with. The immigration rule, Gen 1.11a, the instruction, the family life instruction, and then W. And then if we skip then to paragraph 13 of the particulars of claim at page 370, it says this: the defendant's conduct resulted in breaches of the claimant's statutory rights as detailed below. Each claimant seeks damages arising from the defendant's breach of the claimant's Article 3 rights in relation to 1, imposition of the NRPF condition, 2, the defendant's application of the unlawful NRPF scheme to them, 3, unreasonable prolongation of the denial of them to mainstream benefits, so denial of mainstream benefits to which they were entitled, 4, the defendant's delay in administration of the change of conditions application at various dates prior to the 24th of May 2020, and 5, their inability to access mainstream benefits. 14, the claimants each suffered breaches of their procedural rights under Article 3 ECHR. And then paragraph 16, in keeping with the findings of the divisional court, the defendant acted unlawfully, ultra vires section 6 of the Human Rights Act 1998 by violating the claimant's procedural rights pursuant to Article 3 of the ECHR in denying them access to mainstream benefits where they were or would imminently be destitute. In each case, the defendant imposed the NRPF conditions that were liable to lead to inhuman and degrading treatment, but failed to operate a system that anticipated and obviated that risk. In particular, the defendant prolonged the denial of mainstream benefits, and my lords just read through those particulars at B and C. And then at 17, in the circumstances, each claimant has suffered breaches of their procedural rights under Article 3 and or substantive rights thereunder.
Where you talk about breaches of procedural rights, I mean, is that saying any more than the system which was held to be unlawful wasn't in place?
So what the pleadings are attempting to get to is really 2 components. One is that they were subjected to an unlawful system, and the other is that there was an unlawful delay in determining their change of conditions applications. So in other words, the time taken on an individual application was too long.
But is the distinction between breaches of procedural rights or substantive rights, does that turn on whether or not, at whatever is the relevant point in time, they were destitute or all but destitute?
It does, and I'll come to explain that if I may, because I don't want to jump. That's the kind of meat
Just
of the
trying
question,
to understand
really.
what's being pleaded here.
Yeah. So the basis of the claim was that they were subjected to a breach of Section 6, the duty not to act incompatibly with Article 3. The Secretary of State had acted incompatibly with Article 3 by imposing the NRPF condition upon them as part of a scheme which didn't allow for that condition to be removed at a point at which they faced imminent inhuman or degrading treatment. And so that's the procedural dimension. And the point of using the word procedural was to distinguish that from inhuman and degrading treatment per se.
So that extends to a period before which the inherent danger in the scheme actually came to be realised.
Yes. And so it's in that respect dependent on the limbuela duty, which the claimant identifies.
And you're getting, well, you perhaps will come to this, but and you say that sounds in damages as well, do you?
Precisely, because that...
Independently of whatever damages they're entitled to or would be entitled to if they actually became destitute.
Independently of that. And that was the very question that the preliminary issue was directed towards ascertaining, because if we then go to the defence, what we see is that the defendant denied entitlement to damages short of establishing inhuman and degrading treatment itself. And so we can, just before we go to the defence, if we just take up paragraph 30 and 32 of the particulars of claim at 374, see that paragraph 30 is the claim for just satisfaction following breaches of rights under Article 3, and 32 is the claim for pecuniary loss. And then the non-pecuniary losses, the claim was for £3,000 each at 35, plus the benefits lost by virtue of, plus the pecuniary loss in the form of the benefits lost by virtue of the defendant's unlawful conduct. And so then returning to my Lord Justice Patten's articulation, we then go back to the defence, which is at 352 of the core bundle.
Sorry, I just want to absorb paragraph 32 of the particulars of claim before we go to it.
And 35 is, I think, the pleading of the, you call it non-pecuniary loss, the breach, what you say is their damages claim for breach of these so-called procedural rights.
Yes. Well, that's identifying the sum that's claimed for the sake of simplicity. Taking up my Lord's question on absorption of paragraph 32, the point about dating the pecuniary loss from the point of application will become apparent as we analyse the detail much more. But as it's expressed at 32, the reason it's put from that point was that by that point, at least, the Secretary of State could not dispute that each claimant was destitute, because subsequently they made a determination that they were indeed destitute at that point. And so by the point at which they made the application and supplied all the bank statements and information that has to be put before the Secretary of State to prove destitution, they were already in that state of destitution, which the court said in W was too late, by which point they could already be exposed imminently or indeed to an actual state of inhuman and degrading treatment at that juncture. So can I take the court next to the defence? And this is to get back to why we had a preliminary issue.
Yes.
So the defence, it's paragraphs 7, 8, 32 and 34 that I want to take the court to.
Page.
It starts at 352. So paragraph 7 is just responding to what we said in the particulars about the background, the W case. And what the defendant does by way of its own background at D, well, C is to say there was no determination that the child had in fact experienced a violation of his Article 3 rights, and D, the decision in W merely sets out that there was a real risk in general that when applied the NRPF scheme could lead to a violation of an applicant's Article 3 rights if an applicant was in fact rendered destitute to a sufficient degree to violate Article 3, ECHR, as a result of the operation of the NRPF scheme. And then at paragraph 8, at C over the page on 354, the factual situation in W was far removed from the factual situation of any of the claimants. In particular, W was rendered street homeless and then housed by a local authority. And W had to move school 5 times before he was 8 years old. And then at 32 and 34 on page 361, this is responding to the just satisfaction claim under the heading loss and damage. 32 denies that claim, and then 34 makes clear what those paragraphs 7 and 8 were getting at. It is denied in particular that if the claimants do not establish that their particular circumstances fell below the threshold of severity sufficient to violate Article 3 ECHR, they will be entitled to any damages. As a matter of fact, it is denied that the claimant's situations fell below the threshold of severity to violate Article 3 ECHR at any stage. So what the defendant was saying in the defence was that you have to establish that your treatment fell below the threshold of severity, which means you had to establish that you'd actually suffered inhuman and degrading treatment in order to be entitled to damages. And that's why they were saying W is a different case. They were saying, well, W had facts where he was street homeless, as though W were a substantive Article 3 breach case. So there was a point of legal dispute that arose from the particulars of claim in the defence. And the thinking behind the preliminary issue was that it would be helpful to establish the preliminary issue of whether the defendant's defence that you can only get damages if proving IDT, inhuman or degrading treatment, was correct. Because if that was correct, then each of the claimants would need to go into detailed evidence to establish that they had suffered degrading treatment, or wouldn't be able to establish any entitlement to damages. And the whole element of the claim that focused on the procedural breaches would be irrelevant and could effectively be struck out. So either way, one way or another.
Didn't the county court judge say in his liability judgment that it's accepted they were all destitute by a certain date, so what's the problem? I give judgment for the claimant.
The county court judge did give judgment for the claimants, yeah.
Yeah, of course he did, but didn't he make a finding at paragraph 33 that or record? Therefore, so far as each of the claimants are concerned, say perhaps one of them, it seems the defendant accepted when the change of circumstances application was made that they were actually destitute.
Correct. That's the reason that the condition was lifted, because my lord may recall that the policy required a claimant to prove they were already destitute as the basis for lifting the NRPF condition. And so in each case, the defendant, after a prolonged period of considering the applications, did accept indeed that they had been destitute when making the applications. But that does not amount to a finding or an acceptance that they were suffering inhuman or degrading treatment. And so the defendant's defence was, you need to still prove more than destitution. I accept you're destitute within the definition. You couldn't meet your essential living needs or you couldn't find adequate accommodation. But to get damages, you need to prove the substantive breach of the prohibition on inhuman and degrading treatment. So that was the point of law taken against the claimant's claim. So just to think where we're at, because these claims are still outstanding, of course, in the county court with this appeal on the preliminary issue.
But your position, I take it, is that even if they do become destitute, so that there is a violation, so let's assume there are no causative problems, of Article 3, so they've been entitled prima facie to substantive damages for breach of their substantive rights, there still subsists, by virtue of the prior situation, a right to damages for the breach of their procedural rights.
Yes.
One isn't subsumed in the other.
Yes. So that in a case where a claimant had indeed suffered, let's say, degrading treatment, inhuman or degrading treatment, the claimant would have a claim for damages in just satisfaction in respect of the loss for the inhuman and degrading treatment, but also in respect of the breach of Section 6 duty not to act incompatibly, insofar as that alights on a procedural component. So both those elements would be available in that case. But in a case where the claimant couldn't prove that the procedural dimensions had actually led to inhuman or degrading treatment, they would still have a modest claim, that's why it was put at £3,000, for breach of their right not to be subjected to the breach of duty of a procedural nature. And so what we were seeking to...
Even though it hadn't,
in fact, eventuated, yeah.
Caused them any real recoverable damage.
Well, on that question, my Lord needs to be careful about the way in which Article 3 damages work within the ambit of the concept of just satisfaction, because Strasbourg, in applying its principles, does not require damage in the form of inhuman and degrading treatment. The damage can be anxiety, distress of those forms of those kinds. And so, and often the Strasbourg court will assume that those forms of damage have occurred. So when we get to the damage question, the claimants could still be entitled to just satisfaction damages if they showed anxiety and distress as a result of the procedural breaches. They don't need to show loss in the form of inhuman and degrading treatment that flowed from them.
But Mr. Goodman, if I can just explore your penultimate submission,
Yeah.
where you said a claimant would still have a modest claim even if the risk of IDT hadn't eventuated.
Yes.
Is that a different way of saying every individual who'd had the NRPF condition imposed on them under the old scheme would have a claim?
No.
So how would, for a hypothetical claimant who didn't reach the state of destitution,
yeah,
why don't they fall into the way you just explained it a couple of minutes ago?
The answer to that lies in both Section 7 and Section 8 of the Human Rights Act. Section 7 requires the claimant to be a victim of the unlawful conduct. So the vast majority of people who might have had an NRPF condition, even under the unlawful scheme, were not a victim of that condition. Because Section 8, what Section 8 requires is the language that's used is a more than tenuous connection between the damage claimed and the breach in question. So you can't just say, well, here's a breach at large I'm very tangentially connected to that breach at large, or tenuously connected to that breach at large, I'm entitled to damages. And so the class of claimant here is a class of claimant who, by being rendered destitute, suffered the very form of damage that was identified in W as integrally related to the breach of duty, i.e. they were put in a position of having to become destitute, unable to meet their essential living needs, or unable to find adequate accommodation, before they could approach the Secretary of State to ameliorate the consequences of the NRPF scheme, to request that he do so.
You said a couple of minutes ago that the defendant, at any rate, is seeking to draw a distinction between destitution and inhuman and degrading
Yes.
treatment.
Indeed. And that, my lord, is indeed common ground. So destitution is defined in section 95 of the Immigration and Asylum Act 1999 to mean one of two things: either that a person cannot meet their essential living needs, or that they do not have adequate accommodation. Meeting that threshold, crossing that threshold, is not tantamount to a demonstration of inhuman and degrading treatment. That's common ground. But the vice that was identified in W is that by requiring a person to be destitute before they can ask for the condition to be lifted is insufficiently precautionary to ensure that those who are imminently or already suffering inhuman and degrading treatment can approach the Secretary of State in time to avoid the ultimate state of inhuman and degrading treatment. So just to illustrate that in a factual example to make it easier, if somebody is about to be evicted because they can't pay their rent, they would fall within they wouldn't fall within the limb that says they don't have adequate accommodation, because for the meantime they would. However, they may well know that in 2-3 weeks they're about to be evicted, and they may want to approach the Secretary of State and say, I'm about to be evicted, I need support from the welfare state to house me.
Mm.
They are not destitute, and so could not approach the Secretary of State on the definition as it stood.
I
The Secretary of State says...
I don't remember in W
Yeah.
the distinction being drawn between destitution and sounds an appalling way of
Inhuman
expressing it,
yeah.
but mere destitution and inhuman and degrading treatment.
Yeah.
I thought the distinction was between people who were already destitute and
Yes.
people who were at imminent risk of destitution.
That's right.
The example you give is a good one. I'm all right this week, but next week I'll be street homeless.
Yes.
But is the defendant's answer post post W to say, well, you might be street homeless, but you still have to satisfy a judge far in the future that it was inhuman, degrading treatment.
That's the pleaded defence that led to the preliminary issue. Yes. So the person who's facing eviction would be imminently destitute because they'd imminently be without adequate accommodation. Now, because of W, the policy has been amended. Now that person can apply to the Secretary of State for the condition to be lifted in anticipation of that violation of their rights. Then these claimants and W could not apply because they were imminently destitute but not destitute.
Mm.
And so the opportunity to avert what might have been not just destitution, but inhuman and degrading treatment resulting from being homeless on the streets or forced to in some exploitative compromise in order to be able to keep a roof over your head, or whatever those conditions might be. That opportunity was not available. People could not apply prior to already reaching a state of destitution, and that was the flaw. I'll take my lord to the judgment in Mbuela and in W, which both make clear the distinction between destitution, which may involve inhuman and degrading treatment, but could not do, and inhuman and degrading treatment. But rather than jump there, I'll stick to the point on the first question was about the preliminary issue, so I just want to come back and round that off. So just to understand why the preliminary issue arose, we can look at the position now. So these claims are still live in the county court, subject to whatever is decided here. If the position is as the defendant pleaded, that the only way you can get damages is to prove inhuman and degrading treatment, then each of the claimants will need to go back to the county court and, to the extent that they can, prove they suffered inhuman or degrading treatment. That's the only way they can get damages under Article 3, if that's the right answer. But the claimant's case was that's not the right answer. Of course they can get damages for that kind of what they call a substantive breach, but they can also get damages for the breach of the duty under Section 6, encompassed in imposing the NRPF conditions on each of the claimants, instructing officials to maintain those conditions where the person was not yet destitute but could imminently suffer IDT. So even on the judgment below, if we weren't here in this court and we'd gone back to the county court, even on Mrs. Justice May's judgment, she said that once they'd informed the Secretary of State of their state of destitution, they could pursue a claim in respect of an unreasonable delay in determining that application or a wrongful determination of that claim. So even Mrs. Justice May repudiated the pleaded defence that you could only seek damages for a substantive breach of immigration, of inhuman or degrading treatment. But the question is, and it's raised directly by the defendant's cross-appeal, is it right, as the defendant says, that you can only claim it if there is inhuman or degrading treatment, or is, as Mrs. Justice May said, or as the claimant says, are there dimensions of procedural breach and procedural right that themselves give rise to damage?
All right, well, you'll come back to this.
We will. Well, we'll spend all day on it. I think pretty much that's the central question. So this really is the last thing to say on the preliminary issues. That's why the preliminary issue, therefore, was pursued. It was because it may be that the claimants don't need to go through proving by evidence that they suffered treatment that descended to the levels of inhuman and degrading treatment. And if they don't need to produce all that evidence, there's a much more proportionate way that all of the claimants who suffered a similar exposure to an unlawful system or procedure or breach of procedural right could be entitled to a sum of damages, a small vindicatory sum of what was claimed was 3,000, what was awarded was 2,000 plus 500 for each child, plus non-pecuniary damages. So it presented an opportunity for the court to define, do we need to get into all this evidence? Do we have to have days of oral evidence of hearing from each of these claimants that they suffered inhuman and degrading treatment, all the degrading elements that they were put through by virtue of not being able to feed their children? Or can we cut the Gordian knot of that and get through on a much simpler premise? So that was the appeal to the court, and that's why His Honour Judge Cotter QC directed the preliminary issue.
But it was a preliminary issue where, by the terms of the order, evidence of fact could be admitted, And then what was the county court judge supposed to do with that evidence of fact?
There was sufficient, what he described as assumed or non-controversial facts for him to then go on to determine in his quantum judgment the quantum of damage on the basis that he had found there was a breach of the procedural duty. And that's because, for that very reason that I'm trying to articulate, there was no necessity, if there was a procedural breach, of getting into the nitty-gritty of how degrading the treatment actually was for each of the claimants. Each of them was common ground, subjected to a system which rendered them destitute, and they couldn't apply to be released from that condition until it was, on the authority of W, too late in the day. And so each of them had suffered the consequences of that unlawful system.
But this is because, is it, that the 3,000 claimed, or the 2.5 that was awarded, is sort of, I mean, it's not calculated by reference to anything. It's just a sum which is thought appropriate for as financial compensation for that breach.
Yes, and so the court didn't have to get into. So obviously, if there were much more substantial forms of suffering, you would expect much more substantial damages to reflect that.
Consequences, but I mean, are you saying that I mean, I understand, I think a bit more now what lies behind the premium issue, but assuming it was answered in your client's favour, I mean, was the intention then it would effectively obviate the need for any trial or quantification of damages on the substantive claim?
Well, it hadn't been the original intention, but as it evolved, that certainly became an attractive course. So the original intention was simply to get rid of the defendant's assertion that we had to prove inhuman and degrading treatment, because it meant that we could find a route through to damages without needing to go down the route of live evidence at great extent, which would probably have rendered the proceedings disproportionate for some of the claimants anyway, and quite difficult to justify to the legal consultant. So it was to find a neater solution by which some damages could be awarded.
Even though it wasn't in fact compensating for the loss, financial loss, which they might in fact or not have suffered.
Well, the judge did award pecuniary damages in addition to the non-pecuniary damages that compensated the financial loss, for i.e. the benefits they would have received if the defendant hadn't subjected them to the breach of duty that he did.
But just finally on this, so I can be clear, because I'm not entirely clear. If you turn to the defence, please, at paragraph 34, which is on page 361, under tab 25, just so I can understand. The defendant's case there in 34 for a claimant. You'll need to look at it, Mr. Goodman. It's on page 361.
Yeah. I had it, Miller.
Yeah. There's obviously an issue as to whether the treatment they in fact suffered was sufficient to violate Article 3.
Yes.
And they deny that the claimant's situations, though destitute, fell the correct side of the threshold.
Yes.
And I understand the point about the difference in destitution levels. Is what you're saying on the difference between a substantive claim and or a claim for breach of the substantive rights and a claim for breach of the procedural rights, that distinction doesn't matter?
It does matter.
It does matter. So for a claimant to have a claim their substantive rights under Article 3 would have to be breached?
No.
They would, right? So it doesn't matter. Then.
Well, it matters in terms of quantification of damage.
Well, quantification, but the right to damages, does it matter?
The right to damages exists both for the procedural breach and the substantive breach.
I understand that because you're representing claimants who you say have had both groups of rights breached.
Yeah.
But what I'm asking you is the thinking behind the preliminary issue and your interpretation of the preliminary issue that a claimant who hadn't had their substantive rights breached would still have a claim?
Yes, it is, Mel. Yes.
So in that sense, therefore, that distinction in paragraph 34 to a hypothetical claimant wouldn't matter. They'd still have a claim for damages.
Yes. Right. Yes, in that sense, Mel. Yes. So if somebody, a hypothetical claimant, was subjected to the NRPF scheme, it couldn't apply until they were destitute. They suffered a lot as a result, couldn't meet their essential living needs. That's what destitution means. But they can't say that was inhuman and degrading treatment.
Yeah.
They can still say, my right not to be put in a position whereby I couldn't turn to the Secretary of State at a point at which I was imminently going to suffer inhuman and degrading treatment. That procedural breach of your duty is something that sounds in damages to me as a victim of that breach. Now, the damages would be less, I accept, for the procedural breach in that context than they would be if they showed they in fact suffered inhuman and degrading treatment. But the distinction goes to quantification of damage, not to breach.
But I'm sorry, I don't want to prolong this, but if you put it in that way, I think in response to what my Lord's put to you, I think you are saying, aren't you, that you've got to show that eventually they did fall into destitution.
Into destitution, but not into inhuman treatment. It's important to understand the distinction between the two concepts.
Yeah.
That's a very key point, and I know it's actually a very hard one because I would say Mr. Justice May seems to have confused the concepts in her judgment to some extent as well. But I hope over the course of this day, when we look at it, we'll see that there is a very clear distinction between the two. So,
but why? What's the cause of action if what the claimant suffers is not inhuman and degrading treatment within Article 3?
the cause of action remains sections 6, 7 and 8 of the Human Rights Act. I'll come to these, it will be clearer when we just pick them up. But in summary, section 6 says, Secretary of State shall not act unlawfully, meaning incompatibly with a convention right. Section 7 says a victim can then pursue damages in respect of that breach.
But the relevant convention right is to be protected against inhuman or degrading treatment.
It's important to understand what W said, which of course my Lord does, but the W says that there was a breach of the Section 6 duty by virtue of imposing the NRPF conditions under a scheme that didn't allow them to be released in circumstances where that prevented people from approaching the Secretary of State when they were imminently to suffer inhuman or degrading treatment. And that was a procedural failing which itself breaches Section 6.
Yeah. It's this distinction between inhuman and degrading treatment and other sorts of destitution which
is confusing.
Puzzles me.
Can I come back to that, because that is a central question.
By all means do.
Shall I turn next to the legislation? Because I think if we ground ourselves in that, we may make it clearer. I think I would suggest that we can take a lot of it from the W judgment. So if we take that judgment up, it's at tab 14, page 467. The claimant was a British child of a Ghanaian mother. On a number of occasions, the Secretary of State granted the claimant's mother limited leave to remain in the United Kingdom subject to a condition imposed pursuant to Section 31C2 of the Immigration Act 1971, requiring her to maintain and accommodate herself and any dependents of her without recourse to public funds. The Secretary of State's policy and practice in relation to the imposition of the NRPF condition was set out in Gen 1.11a of the Appendix M to the Immigration Rules, and the Secretary of State's instructions to immigration officers concerning Appendix FM provided that an NRPF condition would normally be imposed unless the applicant for leave to remain had provided satisfactory evidence that he or she was destitute, as defined in Section 95 of the Immigration and Asylum Act 1999, or there were particularly compelling reasons relating to the welfare of a child. The claimant brought a claim for judicial review, and then the holding, one, that although the fact that someone was destitute as defined in Section 95 of the Immigration and Asylum Act did not necessarily mean that he or she was enduring inhuman or degrading treatment, contrary to Article 3 of the Convention, Section 6 of the Human Rights Act 1998 imposed a duty to act not only when someone was enduring inhuman or degrading treatment, but also where there was an imminent prospect of that occurring, in which case the duty was to act prospectively to avoid a breach of Article 3. But therefore the Secretary of State would be legally obliged not to impose a condition of NRPF under Section 31C2 of the Immigration Act 1971, or to lift such a condition where the applicant was suffering inhuman and degrading treatment by reason of lack of resources, or would imminently suffer such treatment without recourse to public funds. So, just to pick up what I was trying to articulate, the imminent suffering, the reason that the Secretary of State has to act at a point at which a breach, a substantive breach, is imminent, is part of the absolute prohibition on inhuman and degrading treatment in Article 3. And that's what's articulated by the House of Lords in Limbuela. So the Limbuela case, which we'll also look at in detail, establishes that it wasn't enough for the Secretary of State to wait until a person was resorting to prostitution or living on the streets. He had to act to anticipate that, and that's expressed in Limbuela as a component of the absolute prohibition, the negative duty not to subject people to inhuman and degrading treatment. Now, that's not a duty at large to house the homeless. It's because the system in Limbuela was pushing people to the brink. And similarly here, the NRPF condition takes away what Parliament has given. Parliament has given these claimants a right to the welfare state if in cases of destitution or entitlement to Social Security. But the Secretary of State, by his executive acts, imposes these conditions which push them to that brink of imminent inhuman and degrading treatment. And where he imposes that system, the anticipatory nature of the implication in Article 3 is he has to also build in an aspect of the system that brings them back from the brink before they topple over the brink. And so there's a duty on the Secretary of State not to just wait until they've toppled over the brink and then haul them back up. It's to stop them ever getting there in circumstances where it's his policy, his NRPF condition that is pushing them to the brink. So just while we're on the holdings at at letter E on 4421 of the judgment, it's explained that the Secretary of State's obligation, I'm just reading just below D, under Article 3 of the Convention and Section 6 of the 1998 Act, and a common law not to impose or to lift a condition of NRPF in cases where an applicant was not yet destitute but would imminently suffer inhuman or degrading treatment without recourse to public funds. And on the contrary, under paragraph Gen 1.11a and the instructions to caseworkers, the decision maker had a discretion whether to impose or lift the NRPF condition in such cases. That to the extent that the regime failed to give effect to the Secretary of State's obligation, it was unlawful, since it was apt to mislead caseworkers and thus gave rise to a real risk of unlawful decisions. So, in a significant number of cases. So, if we then turn to the legislative scheme, which is set out, starts at paragraph 10 of the judgment, which is on page 475 of the authorities bundle. If my lords could just read section 3.1.2c. C2, see the power to impose NRPF conditions. And then it's explained at 11, the imposition of an NRPF condition is therefore expressly contemplated in the 71 Act. A person subject to such a condition is a person subject to immigration control within section 1159 of the Immigration and Asylum Act 1999. That in turn means that he or she is excluded from eligibility for universal credit, income-based job seekers allowance, etc. Together, reading from D, these comprise almost all the benefits to which someone in J's position might otherwise be entitled, including those intended to ensure the basic welfare of dependent children. So the disentitlement comes from section 1159, but whether a person is disentitled from recourse to public funds or not turns on whether the Secretary of State decides to use a discretionary power in section 3(1) of the Immigration Act 1999 to impose a condition. So it comes down to to the Secretary of State's executive decision. And then the policy and practice is explained at paragraph 13. First, there are the immigration rules, which are required by section 3(2) of the Act. They contain statements of the administrative practice rather than rules of law in the strict sense. See ALVI. The second source of policy and practice are the instructions given by the Secretary of State to immigration officers under paragraph 1(3) of Schedule 2 to the 1971 Act. These must be not inconsistent with the immigration rules, but do not have to be laid before Parliament. Paragraph 14 over the page explains that the policy of making grants of leave to remain subject to a condition of NRPF in most cases was introduced on the 9th of July 2012. So prior to that, there was a power, but it was only used on an ad hoc basis. There wasn't a normal presumptive application of the NRPF conditions. And then the immigration rule in question is set out at paragraph 17. Gen 1.11a provides as follows: where entry clearance or leave to remain as a partner, child or parent is granted, it will normally be granted subject to a condition of no recourse to public funds unless the applicant has provided the decision maker with satisfactory evidence that the applicant is destitute as defined in section 95 of the Immigration and Asylum Act 1999. There's then some historical accounts of how the policy evolved, which we can skip. But paragraph 21 sets out the instruction in February 2018, and 22 a limited amendment in December 2019. So in 2018, this was the instruction, so not the immigration rule, but instructions given to immigration officers at H, making a decision on the condition code, where you decide that even though they now have the right to work, if they did not before, the applicant is destitute, including accepting that any previous means of support are no longer available, that there are particularly compelling circumstances relating to the welfare of a child on account of their parents' very low income, or that there are other exceptional circumstances, you should not impose or should lift the no recourse public funds condition code and apply condition code 1A. This code allows recourse to public funds. And then at paragraph 22 is the further version. And it explains, you can exercise discretion not to impose or to lift the no recourse to public funds condition code only where the applicant meets the requirements of Gen 1.11a of Appendix FM of the immigration rules on the basis of the applicant having provided satisfactory evidence that they are destitute, or there is satisfactory evidence that they would be rendered destitute without recourse to public funds. And then at the foot of the page, the court explains the text under the heading making a decision on the condition code and subsequent leave to remain applications was the same as in the 2018 version, which we just looked at. And then at 23 over the page, the court, interpreting those provisions just below letter B, said that the text under the heading making a decision on the condition code tells caseworkers that they should not impose or lift the NRPF condition code when the applicant is destitute, but says nothing about the case where the applicant will imminently become destitute. Paragraph 25 then sets out the definition of destitution that is read across from the section 95. And it explains, as can be seen from Gen 1.11a, that cross refers to the definition of destitute in section 95 of the Immigration Act 1999. Section 95.1 has no direct application to those granted leave to remain under the 10-year settlement route. Its purpose is to confer on the Secretary of State a power to provide or arrange for the provision of support for asylum seekers and their dependents, so separate context, who appear to the Secretary of State to be destitute or to be likely to become destitute within such a period as may be prescribed. By section 95.3, a person is destitute if A, he does not have adequate accommodation or any means of obtaining it, or B, he has adequate accommodation for the means of obtaining it, but cannot meet his other essential living needs. So two forms of destitution that can be reached.
I think it means all the means of obtaining it.
It does, yeah. That should, in fact, yeah. I think in the statute it's correct, but yeah, in the. So one or the other, or both, of course. Now, in the section 95 context, it's then explained at 26 that when you're dealing with asylum seekers, there is a prescribed period of either 14 or 56 days before destitution where asylum seekers can apply for asylum support. But that didn't read across into the Secretary of State's policy. And that, as we'll see, ensures in that context that there is some respect for the anticipatory nature of the Article 3 duty, that it gives the power to the Secretary of State to act before destitution is reached in the Section 95 context. If my lords have absorbed that, then if we skip forward to paragraph 37, after dealing with the common law principles at 37, the heading is the obligations imposed by the Human Rights Act 1998. Since these cases, which means ex parte Sims, the JCWI case, etc., that are dealt with above, were decided, the 1998 Act has come into force. Explains the immigration rules are treated as subordinate legislation, subject to the Section 3 requirement. And then F, even if they cannot be so read compatibly with Article 3, because the material provisions are not mandated by primary legislation, Section 6 obliges the Secretary of State to ignore them if and to the extent they would require her to act incompatibly with convention rights. So an immigration rule, an a fortiori, obviously an instruction, can't constrain the Secretary of State's duty under Section 6. So in context, if the instruction or the duty or the immigration rule inhibit the Secretary of State from assisting people who are imminently facing inhuman or degrading treatment, then they are unlawful, and that's what plays out in this case. Article 3 is then dealt with. Article 3 of the Convention confers the right not to be subject to torture or inhuman or degrading treatment. The House of Lords explained in Limbuela how Article 3 is to be applied in a context with strong similarities to the present one. Section 95 of the 1999 Act allowed support to be provided to asylum seekers who appeared to the Secretary of State to be destitute or likely to become destitute within such period as may be prescribed. Section 95 stated that a person was destitute for the purposes of the section if he did not have adequate accommodation or any means of obtaining it, whether or not his other essential living needs were met, or alternatively had adequate accommodation or the means of attaining it, but could not meet his other essential living needs. If my lords could refresh on paragraph down to 40, 41 and 42, that might be speedier than reading it all out. So pick up at 42, what the court said, that this makes two things clear. First, that someone is destitute as the term defined for the purpose of section 95 does not necessarily mean that he or she is enduring treatment contrary to Article 3 of the Convention. So you can be destitute and not suffering IDT, inhuman or degrading treatment. But equally, it's important to recognise that you can be destitute and might be suffering inhuman or degrading treatment. So if you can't meet your essential living needs, can't wash, can't eat, that could well amount to inhuman or degrading treatment. It's just that it doesn't necessarily so. And then second, Section 6 of the 1998 Act imposes a duty to act not only when someone is enduring treatment contrary to Article 3, but also when there is an imminent prospect of that occurring. In the latter case, the law imposes a duty to act prospectively to avoid the breach. So that's the duty upon which the claimants rely, the duty to act prospectively to avoid the breach. It's a duty that comes from Section 6 of the Human Rights Act, not to act incompatibly with convention rights. And so where it's established the Secretary of State has acted in breach of that duty, it follows under Sections 7 and 8, there is in principle, subject to victim a more than tenuous connection between the damage and the breach, there is in principle a right to claim damages. And so that's why the pleaded defence for the Secretary of State is wrong in saying that you have to establish IDT, and why the cross appeal is wrong. You can only get damages if you actually suffer inhuman or degrading treatment. Can we then go forward to paragraphs 60 and 61? The heading is the legal obligations on the Secretary of State. It's page 492. The analysis begins with three propositions of law, which, as we understand it, are not in dispute in these proceedings. A, there are some cases in which the Secretary of State is not only entitled but legally obliged not to impose a condition of NRPF or to lift such a condition. B, these include cases where the applicant is suffering inhuman and degrading treatment by reason of lack of resources. C, they also include cases where the applicant is not yet suffering but will imminently suffer such ill treatment without recourse to public funds. So, same point. 61, all of these propositions flow from the Secretary of State's concession that in the light of the analysis in Limbuela, paragraph Gen 1.11a would be unlawful if it required applicants to become destitute before they could apply for the NRPF condition not to be imposed or to be lifted. Although the Secretary of State's concession was made on the basis of the reasoning in Limbuela, which was itself based on the obligation imposed by Article 3 of the Convention, in our judgment, the proposition set out at para 60 above would also follow at common law, even in the absence of Article 3. Section 31C2 of the Immigration Act 1971 expressly empowers the Secretary of State to impose an NRPF condition, but it imposes no duty to do so, and it is silent as to when the condition should be imposed and when it should be lifted. In the light of the case law set out above, clear words in primary legislation would be required to authorise the imposition or maintenance of a condition of NRPF, where the effect would be, as Lord Bingham put it in Limbuela, by the deliberate action of the states to deny shelter, food, or the most basic necessities of life. There are no such clear words. In the absence of them, we would hold that Section 31C2 of the 1971 Act does not authorise the imposition or maintenance of a condition of NRPF where the applicant is suffering inhuman and degrading treatment by reason of lack of resources or will imminently suffer such treatment without recourse to public funds. And then at 66, at H, just at the foot of the page, the court says it's tried to stand back and read the documents as a whole. Even applying this broader and less focused approach, reading paragraph Gen 1.11a and the instruction together, we find it's impossible to identify the message that the Secretary of State is under a legal obligation not to impose or to lift the condition of NRPF in a case where the applicant is not yet suffering, but will imminently suffer inhuman and degrading treatment without recourse to public funds. On the contrary, the message conveyed seems to us to be that in that category of case, the decision maker has a discretion whether to impose or lift the condition. This, in our view, has the potential to mislead caseworkers in a critical respect. I'll pause there. So the misleading of the caseworkers in a critical respect is the key vice here. And I'll have to come back to this at some point, because the next sentence is alighted on by the defendant in these proceedings. It gives rise to a real risk of unlawful decisions in a significant and certainly more than minimal number of cases. Now, when the divisional court decided this case, there was a lot of case law about when a court could find that a policy was unlawful, which the court faithfully followed here, but which has then been updated in the decision of A in the Supreme Court subsequently. What A in the Supreme Court said was that what should be applied is the Gillick test. And the Gillick test is in substance what's expressed in that first sentence, that the guidance, the guidance and the immigration rule together has the potential to mislead caseworkers in a critical respect. So if you promulgate guidance that tells your officials a misleading picture of how the law works, then it's unlawful. At this time, there was also this question of whether it created a real risk in a significant number of cases. It also did that at this point. And then at 71, E to F, E, a similar difficulty arises in identifying the point at which inhuman or degrading treatment is imminent. One way of translating this concept, because it's when IDT is imminent that the Secretary of State must act, one way of translating this concept into something more certain and manageable for caseworkers would be by cross-referencing to the phrase likely to become destitute, as used in section 95 and the periods prescribed under that Act. But there's a problem, that might be guidance. Anyway, they say leave that to the Secretary of State. But what the court there is identifying is one possible way of remediating the flaw with the scheme that was adopted. And then the conclusion is the scheme's unlawful as apt to mislead caseworkers. And then at paragraph 76, we see the Secretary of State articulated a form of declaration which the court preferred. And at the next tab, tab 15, is the order of the court. And we see the form of declaration at the foot of 499. It's declared that read together, the immigration rules, Appendix FM, paragraphs Gen 1.11a, etc., are unlawful in that, and to the extent that they do not adequately reflect or give effect to the defendant's obligation under Article 3 ECHR and Section 6 of the Human Rights Act and the common law not to impose or to lift the condition of no recourse to public funds in cases where the applicant is not yet destitute but will imminently suffer inhuman or degrading treatment. So to come back to this core question, we have the threshold of destitution, which we've seen the definition is can't meet your essential living needs, don't have adequate housing. That was used by the Secretary of State as the gateway to being able to apply to have the condition lifted. If you're destitute, then you can come to me. Divisional Court says that fails to respect the Section 6 duty because it doesn't give effect to the duty to lift the condition where the applicant is not yet destitute, so can't satisfy the destitute criterion, but will imminently suffer inhuman or degrading treatment. And so to put that in the factual matrix I described earlier of a person facing eviction, not yet destitute, but imminently to suffer inhuman and degrading treatment by being put out onto the streets, that person couldn't apply.
Just help me on this. I mean, in paragraph 1 of the order that you're looking at, I mean, where it talks about is not yet destitute, but will imminently suffer IDT.
I mean, surely destitute there must mean destitute in the sense identified by the House of Lords as constituting IDT. I mean, it can't mean, in the context, it can't surely mean a level of destitution that would not amount to IDT, because otherwise the order doesn't make any sense.
Well, my lord, respectfully, that can't be right, because the definition of destitution used in the NRPF policy is the one that the court was concerned with in the judgment in W. It's the one that the court was concerned with in Nimbuela in section 95. The destitution.
I know there is a definition of destitution, and I know that it's not all forms of destitution that constitute IDT. That's clear from the speeches in that case. But in W, what was identified as illegal was a system which didn't identify the onset of IDT.
The imminence of IDT, yes.
The imminence of IDT. It's sufficiently in time to prevent it occurring.
Yes.
So that where one is talking then in paragraph 1 about not yet destitute, but will, that must be talking surely about destitution at a level which will engage Article 3.
Well, my lord, if one looks at the policy documents themselves, if we go back to what the Secretary of State's policy was, my lord's suggestion wouldn't be consistent with the way in which the policy themselves seek to describe destitution, and it wouldn't be consistent with the divisional court's finding there was a problem with them.
I'm just trying to understand. The decision of the divisional court is that the obligations on the Secretary of State include one to effectively to prevent somebody's Article 3 rights being infringed by them becoming subject to IDT. So that the procedural vice is in a system which doesn't achieve that. Well, I'm just trying to make sense of what the order said. So where the order says the defendant's obligation under Articles 3 and 6 and a common law is not to impose or to lift the condition of no recourse photographs in cases where the applicant is not yet destitute but will imminently suffer inhuman or degrading treatment. So that in terms is talking about where they're not destitute at all, but will become destitute to a degree that engages Article 3.
Yeah, so there's three situations I think we need to understand. One is where a person is already suffering inhuman degrading treatment. Clearly, Secretary of State's duty applies there. The other is where they are destitute as defined. Now, that may be that they are suffering inhuman degrading treatment, or it may not. There's a range of people who can fall within that. So a person who cannot meet their essential, who does not have adequate accommodation, for example, may not yet be destitute. They may be on somebody's sofa, but you could, may not yet be suffering inhuman degrading treatment. They may be on someone's sofa so that they are destitute, but not yet suffering inhuman degrading treatment. So I've made the categories there a bit. So apologies if I did that. Does that make it clear? So you're not on the streets suffering the levels of severity that amount to IDT, but you are destitute because the only way you're surviving is sleeping on a church floor or some well-wisher's sofa. So it needs to apply at that point as well.
If you don't have the essential living needs, difficult to see that you're anything other than destitute.
Well, you're certainly destitute or anything other than suffering inhuman treatment.
I accept the sofa surfing example. I had thought of that. I just don't recall. In W, we were considering documents which used the phrase destitute again and again.
Yeah.
They didn't say, by the way, there's a distinction between destitute and destitution and inhuman and degrading treatment, did they?
Well, that's what my lordship's judgment identified at 41,
Yeah.
42, page 487, which is that which says that the fact that someone is destitute, as the term is defined for the purposes of section 95, does not necessarily mean that he or she is enduring treatment contrary to Article 3. The threshold of severity which must be reached to make out a breach of Article 3 is higher than that required for finding destitution.
I mean, going back to paragraph 1, I mean, you're not. Would there be a breach if the position were to be that they were destitute in the sense you've indicated, in other words, short of IDT because they had some form of temporary accommodation. And in fact, for whatever reason, they wouldn't imminently get any worse than that.
Yeah. So
At that point, they would not cross the relevant legal threshold.
That is right, taken on its own. But the problem with the Secretary of State system was it didn't have the sensitivity to identify one from the other.
No, but for there to be a breach of the claimant's procedural rights under the legislation and the authorities we've been looking at, they have to be in a situation where imminently they will, not may, but they will become subject to IDT. So that you have to, I mean, this debate is, I think, directed to identifying what the trigger is for a breach of procedural rights as opposed to the substantive right, the breach of substantive rights that will inevitably follow if Article 3 is actually engaged. But my reading of the decision we've just been reading is that you do have to be in a situation where, as a result of the system, you will suffer suffer IDT. It's not engaged if you're simply in an unfortunate situation which undoubtedly constitutes destitution, but won't constitute anything worse than that.
Well, what the Secretary of State's policy sought to achieve, that my Lord has, as it's taken on its own, I accept the articulation of the nature of the duty under Article 3.
Yeah.
Yeah. But the way in which that then translates into a system that the Secretary of State uses was, the Secretary of State thought, well, I recognise this anticipatory duty. I've got to stop people before they go over the brink. The way I'm going to do it is anyone who's destitute can come to me. That system did not respect the Section 6 duty because it was not sensitive to people who could be imminently suffering IDT who were not destitute. So it was a category approach to say, well, if you can't meet your essential living needs or if you don't have adequate housing, fine, we'll lift the condition, because from the Secretary of State's point of view, that's going to be close enough. There's no point in drawing finer distinctions than that. What the court says is even that doesn't anticipate to a sufficient degree, because some people, and we see this in one of the cases quite clearly, ASY herself, she couldn't satisfy the destitution threshold. The Secretary of State sent her back for a second go at applying. But she was imminently about to suffer IDT. She was pregnant and about to have a baby, another mouth to feed on limited resources that she couldn't manage with. So she tried to apply in advance of actually having the baby and all that might come with that. if she'd been left in a position with no money after looking after 3 children, including a young baby, in situations with all the consequences of childbirth, those circumstances could well have been amounting to IDT, and indeed her claim may well be that they did amount to IDT. The Secretary of State's system did not allow her to apply until she was already destitute, and so the system itself did not respect the anticipatory duty.
But
The system doesn't have that sensitivity.
But I understand. But I mean, if the system is at fault because for somebody who will imminently suffer, it doesn't cater for that in the way that the Division Court has indicated it should do. I can see that there's clearly a breach of their procedural rights, and I can see that. I mean, let's take the actual instant case we're dealing with. Most, if not all, of your clients did go on and suffer IDT on the judge's findings.
No, destitution.
Well, okay, but let's be clear. But if they want to assert their substantive rights, they've got to show they've suffered IDT.
Yes, accept that. Yeah.
Now, for somebody in that situation who does go on and suffer IDT, of course, they've got a claim in damages subject to any issues about quantum and so on, the breach of those substantive rights. Now, you told us earlier that wouldn't forfeit in that event their right, nonetheless, to claim for a breach of their procedural rights.
Yeah.
But what about what I'm afraid still not clear about, but perhaps you can now tell me, now we've seen the authority, is if you have a claimant who undoubtedly became destitute and might have suffered IDT, but in fact didn't, so that they never got a substantive claim, are they still somebody who can claim for a breach of procedural rights?
Yes.
Notwithstanding that they didn't, in fact, go on to suffer IDT?
Yeah.
I see, yeah.
But just to be clear about that, because that was the point I was trying to explore with you a little while ago, when I was exploring, you said, I think, and I don't want to put words in your mouth, in my lordship's example, that person would have to be destitute.
Yes.
In order to have a claim for breach of their procedural rights. Is that right?
Yes, because of sections 7 and 8, in order to get through those victim tests.
So your position is really aimed at somebody who has not suffered IDT.
The procedural right is, yeah, or they don't need to worry whether they did or not for the procedural.
Well, it would be difficult to. Well, all right. So you're saying they'd have a claim, but there's a claim under Article 3.
Well, it's under Section 6.
Yeah.
And Section 6 alights on the duty of the Secretary of State. The Secretary of State's duty was breached in their circumstances. They were a victim of that breach of duty, see Section 7. Then you get to the questions under Article 8 of whether just satisfaction is necessary to remedy the breach.
Right. It may well be we have to come back to this, but that
we
seems
do, I
to
mean,
be slightly different.
It's a hard case, and we have to go round
No,
and
but
round.
it seemed to be slightly different to the first answer you gave me this morning. Can I just be clear what the categories of persons are who you say will have a claim for breach of procedural rights, when my lordship's explanation is they don't have a claim for substantive rights?
Yes.
Because they don't in fact suffer IDT.
Yes.
What does their condition have to be?
So in each of these claims, I say whether or not they can establish IDT, they are entitled to damages in respect of the breach of procedural rights. So precisely my lord's postulated category applies to these claimants. They don't need to go on to prove IDT or not.
No, I understand that. I'm
And-
talking about the point of principle of a hypothetical claimant.
Yeah. Okay.
Do they have to be destitute?
So they do have to be destitute because
Right, that's
Section 7.
they do have to be destitute.
So they have to be destitute to be victims under Section 7,
That's yeah.
and also at imminent risk of suffering inhuman or degrading treatment.
Well, that's not going to be possible to establish because of the way the Secretary of State's breach of duty operated. So the problem there is that the Secretary of State's policy didn't allow people to come forward until destitute. That's the whole vice of the policy that's found in W, that the Secretary of State postponed the point at which anyone could actually claim to be imminently suffering IDT until they were destitute, but then treats everyone who's destitute as eligible for the condition to be lifted pursuant to the duty under Section 6 and Article 3. That's how the policy worked. But that policy was unlawful because it didn't allow earlier applications for people who said, I am imminently going to suffer IDT.
Yeah.
It didn't allow people to say that.
Yes.
So that was the very vice of the policy, is that it inhibited people from making their claim that I'm going to imminently suffer IDT. It didn't allow for that process to happen. That's why it's a procedurally defective system that was declared unlawful.
But it, I mean, you have to accept that for the category of person that I put to you, it would mean that they can get damages because, so to speak, they were living under that system, even though in fact they could never have claimed. I mean, it didn't cause them any damage in the sense that they were prevented or delayed in making a claim because they never had a claim.
What does
They
my law
never
mean by
became subject to IDT. I mean, yes, they were destitute.
They're never subject to, yeah, that's right. They're never subject to IDT itself.
I mean, their Article 3 rights were never actually breached.
Well, the substantive ones weren't.
No, that's what I'm talking about.
The substantive ones
they
don't.
can, in a way, I mean, I don't say this disrespectfully, but they are really piggybacking onto the claims and positions of somebody who did, in fact, whose situation did worsen to a point where there were substantive breaches of their Article 3 rights, simply because potentially that might have been the position for them, but wasn't.
My Lord's way of analysing it is one which, in my submission, is flowing from our common law understanding of the way in which damages are there designed to remedy a specific loss to an individual.
Yeah.
Whereas damages in the Human Rights Act and in the Convention context are there primarily to mark the breach by the state. And so that's why Section 6 of the Human Rights Act, in giving effect to that underlying principle of the Convention, makes it unlawful for the Secretary of State to act in a way which is incompatible with the right, and why the damages provisions...
That doesn't create a cause of action for the world at large, though.
No. That's why Section 7 and 8 say you have to be a victim of that particular breach, and under Section 8, just satisfaction has to be necessary. So one answer can be, dependent on the facts, there is a breach, there is a right to claim damages, but just satisfaction is not necessary to remediate it. And you see a wealth of cases where the courts will say a declaration is sufficient because that's met the ambitions of the Convention and the Human Rights Act implementing that. But that's a fact-specific analysis that takes place at the question of just satisfaction. It's not a question that goes to whether there has been a breach under Section 6 that in principle opens an entitlement.
I must say I can't see the point of that. I mean, W brought a claim and succeeded in obtaining a declaration that Gen 111A was unlawful. And no doubt many others could have done the same. So lots more people might have been entitled to a declaration that Gen 111A was unlawful. But so what?
Yeah.
I mean, why should anyone be able to get a sum of money by way of just satisfaction, unless they were victims within the meaning of Section 7, and that seems to me, at any rate, to mean not just theoretical victims, of which there might be millions for all I know, but people who actually suffered some measurable breach of their rights, in the sense that their lives were made considerably harder, at least for a period.
Yes, that's right. So under the just satisfaction analysis under Article 8, as under Section 8 of the Human Rights Act, that is the correct way to look at it. So by the point at which you get to Section 8, it's established there as a breach and that they were a victim of the breach. The question then is, just satisfaction necessary to remedy that breach? And if they've suffered in no way at all, the answer is no. But the suffering itself doesn't have to be inhuman or degrading treatment. That's what the authorities make clear at Strasbourg level, that they have suffered to some extent, which clearly these claimants did, and that's what the county court judge found, is sufficient to give rise, in principle, to an award of damages. Quantum will depend on how much they've suffered.
So it's living under that. It's living under that state of affairs, suffering, distress, anxiety, etc., etc.
Yeah. So can I illustrate that by reference to the facts of one of the cases, just because I think it will help to picture it rather than do it entirely in the abstract. And I'll take it from the Secretary of State's evidence below to start with, so that we're not getting into questions of controversy. So supplementary bundle 326. So this was in the county court. The Secretary of State put in a witness statement. Of Sarah Fairbrother of the Home Office. And the case I'm going to look at is ASY's case, which is set out at page 337. There's a brief summary of the facts, essentially, on the Secretary of State's case.
Sorry,
337 of the supplementary bundle. So we see she arrived in 2008 with a visitor's visa. 2014, she applied for leave to remain on the basis of a relationship with a British partner and 2 British children born in 2010 and 2012. 2014 application granted, valid till 2016. 2016 she applied for further leave to remain on the 10-year route. 2017 application granted. Then 19th of June 2019, AY made a change of conditions application by requesting recourse to public funds. 30th of July, the application was assessed, and you see over the page that the answer was, has Lim Watton been met? No. And so at 54, the caseworker emailed AY requesting the following further evidence by the 13th of August 2019. A breakdown of monthly income and expenditure. B, 6 months annotated bank statements, etc. On 16th of August, no response was received, and we'll see in her statement, she said it was sent to the wrong address, or the same email, so I'm not sure exactly how to resolve that conflict here. 28th of August 2019, the COC application was rejected after the evidence requested was not supplied. So a fresh application is made in 12th September 2019 and granted on the 21st of October 2019. So that's the bare outline. And then we have the witness statement of Caroline Hatton, which starts in the supplementary bundle, page 2. Caroline Hatton works at the Unity Project, which is a charity which helps people make these applications. And her evidence relevant to this case is at supplementary bundle, page 23, paragraphs 50 to 52. There's AY. According to our records, AY first contacted us on the 3rd of October 2018 So remember, the condition was lifted in 2019, so this is a year before. We called her back and were able to offer her an appointment on the 20th of November 2018, but at that appointment we advised that her application would likely be refused as she could not show to the Home Office satisfaction she was already destitute. AY contacted us again in March 2019 as her situation had worsened considerably. It took 3 months to gather the evidence she needed to meet the Home Office's requirements for demonstrating destitution, and the application was submitted on the 14th of June. Well over 2 months later, the Home Office wrote again on the 28th of August saying they had asked for more information which was not provided and therefore refusing the application. AY told us she had not received the letter as it was sent to the wrong address. We therefore helped her to submit a further application on the 12th of September 2019. It took 39 days for the Home Office to lift the condition, which finally happened on the 21st of October. I'm told the defendant's internal records show the Home Office accepted the application on the 1st of October, but 20 calendar days elapsed before providing a decision letter. And then she sets out the detail of how long it had taken and explains that she was arguably imminently destitute over a year earlier, but that predated the W judgment, so we didn't know the Home Office's policy was unlawful in the respect of not allowing imminent destitution as a criterion, so we advised her an application at that stage would be unsuccessful. So that's the person who helped her make the application's evidence, and then we've got a statement from her as well. Which is at the supplementary bundle 199. And if we turn over the page from 199 to paragraphs 3 and 4, I'm a Ghanaian citizen, I've lived in the UK since 2008, etc. And then 7 and 8. So 6, 7 and 8, she explains she was living with her sister. Her sister moved out. She was left to pay the rent by herself. She couldn't afford it, as the rent alone was more than she was earning each month. Because of the eviction notice, she had to move quickly. I was desperate and needed somewhere near my work and near my children's school. From the 14th of January, she moved into other accommodation, a flat with my children. The rent was £1,448 a month, including utilities. But it was still very hard to find somewhere to live when you need to move quickly and have 2 small children. All of my income was being spent on the rent, with nothing left for other living essentials. On the 1st of April, the rent increased. I was working full-time as a healthcare assistant for Barking, Havering and Redbridge hospitals in Romford, Essex. I was paid £9.60 per hour and earned roughly £1,450 per month. I worked mostly night shifts, usually 3 or 4 nights a week, as I was unable to afford childcare during the day. My colleague who lived near me would sleep over at my house during my night shifts so that I could leave my children alone. I became pregnant at the beginning of 2019 and knew that I would be unable to work as of August 2019 without recourse to public funds. I did not know how I would support my family if I was not working, as it was already difficult for me to do so. I was and still am unable to obtain support from my children's fathers. And then she explains 11 that her sister gave her occasional £20, and the only other regular income was at that time child benefit. 13, this was already not enough money for me and my children, and when I became pregnant I knew I needed more support. A newborn baby needs regular items such as nappies, clothing and food, as well as equipment such as bottles of cotton and pushchairs, to name a few. I was so scared about what would happen to me and my children. We were already on the brink of destitution, but I knew that things would get worse once I stopped working and had my baby. I received maternity pay for 9 months. The first 3 months on full pay and the last 6 months on half pay. I was worried when it stopped I would be completely unable to support my family. I also had debts to pay. I was arrears of council tax and owed water bills. So then she explains about the change of conditions application. She found out about the Unity project. And then 18 explains on the 14th of June she submitted the application along with all the evidence she had of destitution. And she exhibits the application. I'll take my lords to that in a moment.
You know the case better than I do, Mr. Goodman. I'm not sure we need more detail than that for,
Fine.
for the present
Yeah.
purposes. I mean, it's useful to see an outline, saying, but she is saying that on any view, whether or not you allow the Home Office a reasonable time to reply to the COC application, on any view she had several months during which she should have been receiving support but wasn't because of the policy. And even before that, she would have made an application but was deterred by them.
Yes, and the particular context of her case, we see at 21, is that she was about to have a baby in October.
Yes,
And one can see how that imposes a new pressure that would tip you potentially into inhuman and degrading treatment. And she goes on to describe the consequences for her, but I accept this is only illustrative because we're not dealing with the facts on the preliminary issue. But she doesn't in fact get the condition lifted until after her baby's born, and then she has to go through another process of applying for benefits and waiting for what's called a BRP, a biometric residence permit. She explains at 29 that that's another period of delay after the condition is lifted. So lifting the condition isn't the magic end to the situation she's in. She then waits for another administrative process, then applies for benefits.
And it's not backdated at all when it has come, or is it?
So the welfare system can backdate from the moment of your application for the social security benefits, but can't backdate to a point at which prior to when you apply. So that's one of the features of the NRPF scheme.
Happened? Was it were benefits backdated to June or not?
No, they can't be. There's no discretion for the social security system to do that. So she can only apply once the condition's lifted.
Oh, I see. Yes.
So your answer was confusing. You said benefits can be backdated to the date of the application, but you meant the application for benefits.
The benefit,
Sorry,
not to remove NRPF. Okay.
Yeah, but that's one of the structural ways in which the Secretary of State could have designed the scheme in a way that didn't infringe Article 3, because what the Secretary of State could have done is lift the condition immediately that you ask and say, well, go off and apply for the benefits, and rather than bake in this additional delay where I decide whether you're destitute as well, I'll do that alongside the welfare system's operation. So, of course, it's up to the Secretary of State to design his scheme how he likes, but that's one of the safety valves that could be put in, or could have been put in, which would make it easier to comply. Because then, of course, as soon as you put the application in, your benefits, however long they take to come through, will backdate. You can pay off debts and borrow money in the interim to keep afloat.
Yes, thank you.
So that gives a flavour, and it, I hope, puts into context these categories that we're thinking about. That after her baby was born, there was a real risk in my submission, or would be submitted if I need to, that she would suffer inhuman or degrading treatment, and maybe even did, looking at the way her evidence is pleaded about the desperation she was put in of having no money to cover anything beyond rent and a newborn baby. So that's the after the baby's born position. We've also got destitution position, because we know the Secretary of State accepted when she made the second application that she was destitute. So we know that they accepted that she did not have either adequate accommodation or, probably in this case, money to meet her essential living needs. That was in October. And then we have the evidence that before that she had sought to anticipate these problems arising by moving earlier, and was told, well, you can't because you have to be destitute and you're not destitute yet. And that's the difference that W made, was that this person could apply earlier rather than finding herself with a newborn baby and no money to buy nappies and clothes and to be able to feed it. And that's why the Secretary of State's system breached the duty to anticipate inhuman and degrading treatment, because it didn't allow her to approach the Secretary of State and say, I need this support, my circumstances have changed. So can I then take my lords to Limpueda? That's tab 6 of the authorities bundle. So the point that we're going to take from Imbuela is that this is the case that establishes that by Section 6, the duty is to act to anticipate inhuman and degrading treatment. And so in my submission, that's a very simple answer to the preliminary issue that was in front of the judge in the county court and is at the heart of this appeal as well. That Imbuela says there can be a Section 6 breach where there is no inhuman or degrading treatment proven.
It is not wait and see.
Not wait and see is one of the terms used, yeah. So Imbuela was a case about destitute asylum seekers. We can see that in the first lines of the head note. And it related to the Section 95 definition of destitution, which is used in the NRPF scheme. So it's a closely related context. And the way in which the legislation worked, we see a reference there to Section 55, was to say that if you apply for asylum late, you're not going to be entitled to support. So you turn up, but you don't claim on arrival at the port or whatever the case may be. However, you are entitled to support if it would breach the Secretary of State's Section 6 duty to respect your convention rights. So the Section 55 empowered the Secretary of State to provide support, if, but only if, that was required as a matter of Section 6 as well. So we see that in the judgment of, well, before we get there, we see in the argument, first of all, 121 of the bundle, that the argument for the Secretary of State on appeal at F on this page was that the decision, that was the decision to remove support, Section 95 report, remains lawful unless the suffering reaches such a degree of severity that the court is bound to limit the state's right to implement the policy. So that word severity, Lords will recall, reflects the defence for the defendants in this case. Lord Bingham's judgment comes first. Paragraph 1 frames the question: in what circumstances does the Secretary of State become entitled and obliged, pursuant to Section 55(5)(a) of the Nationality, Immigration and Asylum Act 2002, to provide or arrange for the provision of support to an applicant for asylum where the Secretary of State is not satisfied the claim for asylum is made as soon as reasonably practical? So it's both entitled and obliged under that statutory power. And then at paragraph 3, he sets out Section 95. And then paragraph 5 explains the Section 55(5)(a) authorise the Secretary of State to provide or arrange for the provision of support to a late applicant for asylum to the extent necessary for the purpose of avoiding a breach of that person's convention rights. So the question was, when does that duty, that power arise, i.e. when is it necessary for avoiding a breach of convention rights? And then he continues, he may only exercise the power to provide or arrange support where it is necessary to do so to avoid a breach, and to the extent necessary for that purpose. He may not exercise his power where it is not necessary to do so to avoid a breach, or to an extent greater than necessary for that purpose. Where and to the extent that exercise of the power is necessary, the Secretary of State is subject to a duty and has no choice, since it's unlawful for him under Section 6 of the 1998 Act to act incompatibly with a convention right. So, in other words, whatever the answer was to where the Section 55 power ignited, that was coexistent with where the Section 6 duty kicked in. So, although the case is primarily concerned with a domestic provision in a separate statute, Section 55, everything that we see is then said about it also applies to the extent of the Section 6 duty under the Human Rights Act 1998. And then, if my Lords would read paragraphs 7 and 8. Seven concerns what is treatment.
the great Lord Bingham seems to be saying here that if you have no alternative, if you have no means and no alternative sources of support, and you are, by the deliberate action of the state, denied shelter, food, all the most basic necessities of life, that is inhuman or degrading treatment.
Yes. But the key point is line 4 of paragraph 8. When does the Secretary of State's duty, because he expresses the power as a duty because of section 6, under section 55 arise? The answer must be when it appears in a fair objective assessment of all the relevant facts and circumstances that an individual applicant faces an imminent prospect of serious suffering. So it doesn't arise at the moment of serious suffering, it arises at the moment of imminent prospect. So, my lord, to go back to the W judgment, the reason that the policy in W was unlawful was that it foreclosed the Secretary of State's ability to comply with her section 6 duty. It created circumstances in which people who imminently face IDT would not be released from the prohibition on public funds unless they were also able to show destitution. So CASY's case, she was destitute for a long time before she gave birth. It's a good example of where a person may not be destitute, but is well aware that they imminently face, could imminently face IDT if they're not allowed recourse to public funds. The Secretary of State's policy prevented those people from applying in advance in anticipation and thereby didn't comply with the anticipatory component of the Secretary of State's Article 3 duties. And then can I just take the court to paragraphs 40 and 62 in Lord Hope's judgment. So 40 is on 133.
Yes.
Section 55 had to be read together with section 6, so same approach of the two being construed together. And then 62. The best guide to the test that is to be applied is, as I have said, to be found in the use of the word avoiding in section 55(5)(a). It may be, of course, that the degree of severity which amounts to a breach of Article 3 has already been reached by the time the condition of the asylum seeker has been drawn to his attention. But it's not necessary for the condition to have reached that stage before the power in section 55(5)(a) is capable of being exercised. It's not just a question of wait and see. The power has been given to enable the Secretary of State to avoid the breach. A state of destitution that qualifies the asylum seeker for support under section 95 of the 1999 Act will not be enough. But as soon as the asylum seeker makes it clear that there is an imminent prospect that a breach of the article will occur because the conditions which he or she is having to endure are on the verge of reaching the necessary degree of severity, the Secretary of State has the power under section 55 and the duty under section 6 of the Human Rights Act to act to avoid it. And then Lord Scott is 66 to 71 deals with the question of treatment again. And then at paragraph 72, analyses section 55 again. And then Baroness Hale, paragraph 75, same point that the power in section 55 to avoid a breach is an expression of section 6. that's at E. Thus was the duty of any public authority under Section 6 of the Human Rights Act to refrain from acting in a way which is incompatible with the Convention right liberally preserved. So the power to avoid a breach is itself she articulates an articulation of the Section 6 duty. And then Lord Brown's speech at 80 onwards. Parliament's purpose in enacting Section 55 is thus plain. The Secretary of State is not to assist late claimants, as I shall call them, unless that is necessary to avoid a breach of their convention rights, in effect their right under Article 3 not to be subjected to inhuman or degrading treatment, in which event assistance is mandatory. The Secretary of State has no discretion in the matter. Rather, he must determine the facts and then make a judgment. In particular, he must make a judgment as to what level of deprivation engages Article 3. On page 7, the rival arguments are essentially these. The respondents and the interveners point out that Article 3 is often analysed as including both negative and positive obligations, the state being not merely prohibited from itself mistreating individuals, but also on occasion required to take positive steps to prevent individuals suffering at the hands of others, or indeed from natural causes. The state's negative obligation is said to be absolute, its positive obligation not so. State activity causing suffering of sufficient severity is categorically forbidden. State passivity may be justified. So that's summarising the rival arguments. And then what he says at 91 first of all, at G. The final sentence is quite helpful. He says, assume the ban on working were to be lifted and a complaint then made by someone obviously unemployable, surely the approach would not be fundamentally different. So there's no magic in the fact that these claimants could work, because if they're unemployable, see for example ASY, who was about to have a baby, that doesn't get them out of inhuman and degrading treatment. And then at 92 he says, I repeat, it seems to me generally unhelpful to attempt to analyse obligations arising under Article 3 as negative or positive and the state's conduct as active or passive. Time and again, these are shown to be false dichotomies. The real issue in all these cases is whether the state is properly to be regarded as responsible for the harm inflicted or threatened upon the victim. This analysis leaves aside those cases where special duties are found to arise. So, it's pausing there. I adopt and commend that caution about adjectives and labels and subcomponents of what is a very straightforward, articulated Article 3 right. In my submission, it caused a lot of trouble for the judge below, which I'll come to below, using these kinds of adjectives and labels. And so what Lord Brown suggests is that the real issue is whether the state is responsible for the harm inflicted or threatened, and that's consistent with the way in which Lord Hope analyses it. To use the metaphor I used earlier, the Secretary of State is pushing a person to the brink, and they need to pull them back because it's their act of pushing them to the brink that's taking them there. It's not a natural cause. It's not a third party. And so it's part and parcel of the duty not to inflict inhuman and degrading treatment that requires pulling the person back from the brink. And Lord Brown makes clear that that analysis of responsibility for the harm leaves aside special duties found to arise. For example, the duty to hold an effective investigation into allegations of torture, the duty to enact effective criminal laws to protect the vulnerable from Article 3 ill treatment by private individuals, and the duty to take effective operational steps to guard against such ill treatment. So he's saying this is a manifestation of the primary duty about not inflicting inhuman or degrading treatment. It's not about all of these positive obligation procedural cases that the defendant refers to in great detail. So it's not about the duty to take operational steps to avoid harm, Osman type cases where you know a real immediate danger. He's saying it's not about the framework duty to have an effective system of laws. And it's not about the investigative duty, it's just part of the basic duty not to inflict inhuman or degrading treatment.
Okay, anything else from
That's all in Whaler.
Right.
And then the only other case I want to take the court to in detail on this part is a case of DMA, which is a more recent judgment, which is tab 16. Now DMA is post W, and so analyses the content of the Section 6 duty in the light of that. The circumstances in DMA were that there were failed asylum seekers. So after you've claimed asylum and failed, the asylum seeker is no longer eligible for Section 95 support. They're left effectively without support. Clearly that then engages the Limbuela type considerations of them potentially being left on the streets. And so there's a statutory scheme which brings them back from the brink, requires the Secretary of State to act before they reach inhuman or degrading treatment levels. And we'll see that scheme in play here. And the complaint here was, we've made this application to you for Section 4 support, which is what's provided to alleviate destitution, and you've taken between, on these different facts, 45 days and 9 months to determine our applications. That's in breach of our procedural right that you should anticipate and obviate the risk of inhuman degrading treatment. So if my lords just have a look at the head note, you'll see that set out there. And then over the page of the holdings, first of all, the periods of time for which the Secretary of State had failed to provide accommodation to the claimants, having accepted that she had a duty to accommodate them under Section 4 of the Immigration Asylum Act 1999, was such that on any view, they were not reasonable, and that accordingly a declaration would be granted the Secretary of State had been in breach of her duty under Section 4. So this is the periods took 45 days to 9 months for her to determine these applications for relief from destitution. 2, that in order to meet her duties under Section 4, the Secretary of State had to put in place a system for properly monitoring the provision of accommodation, accompanied by arrangements to secure action by reference to the information which such monitoring provided, so that she could know whether she was acting lawfully and in accordance with her duty, and could act immediately if there was a sign that either that was not the case, that proper monitoring in relation to Section 4.2 would amount other things, and he sets out what that would do. And then at F to G, my lords will see that the monitoring arrangements put in place by the Secretary of State either did not happen or did not work, with the consequence that there was a real risk of a breach of the Secretary of State's duty to provide accommodation under Section 4.2 in a significant number of cases, and that accordingly a declaration would be granted that the Secretary of State was in breach of her duties under Section 4 and Section 6 of the Human Rights Act. So it's useful on Section 6 again. And then turning to the judgment of Miss Justice Robin Knowles, paragraphs 1 to 5 set out the basic facts. And then paragraph 10 explains the statutory context here. And section paragraphs 8 through to 10. And the key point is that the Secretary of State doesn't provide accommodation and assistance to failed asylum seekers, but then there's a proviso that she may do so, and the Secretary of State accepted that should be read as must, to avoid a breach of human rights. So, and then paragraph 12. In the present proceedings, the relevant condition set out in paragraph 2 of regulation 3 is E. This is the condition to using the power to accommodate. The provision of accommodation is necessary for the purpose of avoiding a breach of a person's convention rights in the meaning of the Human Rights Act 1998. And it explains that's Article 3, paragraph 13. This prohibition is not a qualified right, it's absolute. Section 6 of the Human Rights Act 1998 provides it's unlawful for a public authority to act in a way which is incompatible with a convention right. Section 6.6 makes clear that an act includes a failure to act. And he then looks at the regulations further at 15, and then the Limbuela case is considered at 16 and 17. So here, the key point is that the regulations say the person shows they're destitute and it's necessary to avoid a breach of their human rights. The Secretary of State must act to accommodate them. And the question is, how long can he take over that decision? And these claimants all said much too long, 45 days and upwards. And so the case was all about where you've got a person who's already destitute, how long can you spend idly considering their application? And sorry, it's not a matter of considering the application, it's where they've been accepted to be destitute, but how long can you spend before you actually provide accommodation or offer accommodation to them? So where it's already agreed that they're destitute. And page 540 of the bundle, paragraph 174. So the argument was for DMA, AHK, BK and ELN that the law requires the provision of accommodation to be upon the decision on an application for section 4.2 accommodation or within a reasonable period of that decision or expeditiously. So because upon the determination that they are destitute, the Limbuela considerations are in play, the allegation was you've got to move very quickly. At that point, they're already destitute and could well be facing, if not already facing, IDT.
Well, the guidance itself said the accommodation should be provided within a matter of days.
Yeah.
To be accepted.
Exactly. So it's very helpful because that's a context where destitution is already established. Secretary of State's own guidance is saying a matter of days. Contrast these claimants who had to go through lengthy hoops before they could establish destitution and are similarly then exposed to delays of between 40 and 65 days in these cases before the Secretary of State processes the application, which then leads to a process of providing a biometric residence permit, which then allows them to apply to alleviate their destitution. So in the Section 4 context, the Secretary of State accepts, I've got to move really fast here because otherwise IDT might eventuate. And we can see that as a contrast to where we've got destitute people under the NRPF scheme. And then the declaration sought was at 177. And we see the breach of Articles 3, ultra vires Section 6 of the Human Rights Act at C is what was sought. And then at 183, the reference to context is of course particularly important for present purposes. The context is that a breach of Article 3 is imminent. The situation is best seen as one involving the prevention of inhuman and degrading treatment rather than simply as a case involving the provision of accommodation. In a particular case, before a decision is reached, to accept the duty to accommodate, there may be a question whether an individual is destitute or whether a breach of Article 3 is imminent. But at the point of the Secretary of State's Section 4.2 decision made through her officials, that question has been answered in the affirmative. He then goes on to note the submissions that time would already have passed in reaching the Section 4 decision. And the submission was made that in some cases, before the decision time will have elapsed, the policy choice of Parliament and Government has been to close release valves and engage the duty to accommodate at a point that leaves no room for delay. And then he refers to the case of MK, in which, in a similar context, 15 working days there was a barrier that required 15 working days for processing accommodation. And that was said to be in breach of Article 3. And then the argument of the Secretary of State at 188 was that it all depends on the actual facts of the case. So he says, by way of example only, a delay of 48 hours may be wholly unreasonable in the case of street homeless vulnerable female with significant health issues, whereas a delay of 4 weeks, whilst not ideal, may be reasonable in the case of a healthy male who is able to access a roof over his head each night and food each day, even though the circumstances were less than ideal, and where in fact no breach of Article 3 occurred during the 4-week period. The first part of the example, the vulnerable female with significant health issues, is sound. The difficulty with the final limb of the second part of the example, the healthy male, is that it uses hindsight, where in fact no breach of Article 3 occurred. Hindsight is not available when the Secretary of State has a duty to provide accommodation within a reasonable time. And I say that's a consideration which applies in this context as well. When people are applying under the scheme that the Secretary of State had set up, all that they are entitled to do is set out how they are meeting the destitution threshold. The scheme has no sensitivity to moving faster in the case of somebody who is imminently or is suffering IDT, and no sensitivity to allow people who are imminently suffering IDT to apply before they're doing so, before at the moment of destitution. So this comes back to some of the discussion earlier around the entitlement to damages, and why I say that the entitlement alights upon the breach of duty by the Secretary of State in setting up a system that failed to secure the procedural right not to be exposed to a risk of inhuman and degrading treatment, not around an every case fact-sensitive analysis of whether that IDT eventuated, or even whether imminent IDT eventuated. That's the way Section 6 is structured. Paragraph 196, then, of this judgment concerns the time taken in the claimant's cases, and he says, in the result, the answer to these proceedings is not that a reasonable time means a fixed period, whether 24 hours or 9 days or some other period. Rather, the periods of time seen in the present proceedings are such that, on any view, they're not reasonable. Indeed, they're so large that, absent an explanation, they do question the system. 198. Mr. Tam argues the delay in each case was reasonable because at no point between the Section 4.2 decision and the provision of suitable accommodation was any of the claimants in fact street homeless or otherwise without food or shelter. The circumstances did not actually cross the Article 3 threshold and amount to inhuman or degrading treatment and did not deteriorate. It's argued that accordingly the policy objective of Section 4 was achieved. And he says this argument relates to the help given by charities or sometimes friends or church which were not prepared to see the Article 3 threshold crossed. Jumping a sentence, it was achieved despite the failure of the Secretary of State and her officials to provide the accommodation that in each case she had by her Section 4.2 decision recognised she had a duty to provide and provide within a reasonable time. And then the declarations, so if we then go to the just to pause there. So what will then come to is the declarations, but what we see here is that there was no proof required of inhuman or degrading treatment. And then page 568, at paragraph 333 of the judgment, the second declaration, the Secretary of State was and is in breach of her duties under Section 4 of the 1999 and Section 6 of the 1998 Act in failing properly to monitor the provision of accommodation under Section 4.2 of the 1999 Act. And the first one was in breach of Section 4 duty in a reasonable period of time. So we can see here the procedural nature of the Section 6 breach. No IDT proven. And then he goes on to consider damages. And he explains 337, Section 8.3 provides no award of damages is to be made unless, taking account of all the circumstances of the case, the court is satisfied that the award is necessary to afford just satisfaction to the person in whose favour it's made. See Greenfield. In D, this is the War Boys case in the first instance. In D, the Commissioner of Police for the Metropolis, the court, Green J, said the starting point is to ask whether a non-financial remedy is sufficient just satisfaction. To determine this, the court will ask firstly whether there is a causal link between the breach and the harm which should be appropriately reflected in an award of compensation, in addition to other remedies. And secondly, whether the violation is of a type which should be reflected in a monetary award. Green J identified the range of factors the court would need to consider: the nature of the harm suffered and treatment costs, the duration of breach by the defendant, the nature of the failings, whether they were operational and or systemic, the overall context of the violations, whether there was bad faith. And then where the award sits on the range of awards made by Strasbourg, and in similar domestic cases, other payments for totality and modesty. And on the facts of this case, at 341, as Justice Robin Knowles says, in my judgment, harm was suffered by reason of delay and to vulnerable people. The harm suffered was not nominal, and the delay was far from minimal. Except there was no bad faith, the delay was not deliberate, but it persisted, and there was a choice not to do more about it. An award of damages is necessary, but taken with the declarations, a non-nominal award of £1,000 to each claimant who claims damages is sufficient for just satisfaction. This case is not about money, it's the declarations that matter. So we see an application of the principles that I've been advancing. Here there is no substantive inhuman or degrading treatment. The breach lay in a failure to comply with the Section 6 duty in a procedural sense. In principle, the accepted damages were applicable. The basis for assessing those is whether there's a causal link between the breach and the harm which should be reflected in an award of compensation. So the harm doesn't need to be inhuman or degrading treatment. And that's evident from the way in which Mr. Justice Knowles then determines it. He looks at the forms of harm, applying Mr. Justice Green's guidance in the D case, identifies the harm was not nominal, and awards a small sum of damages to mark that breach of duty by the Secretary of State. So the structure of what Mr. Justice Knowles does there is precisely what I submit is the correct approach in these cases. That there's a breach of duty by the Secretary of State under Section 6, that turning to the question, it's not disputed in any pleadings anyway, there's a victim, these are victims of that breach. You turn to the question, is there a causal link between the breach and the harm which should be appropriately reflected? That's exactly what the judge in the county court did and looked at and said, well, we're not dealing with disputed evidence here, but it's pretty self-evident that people suffering under this breach would have suffered anxiety and distress. He gives £2,000 to each adult claimant and £500 to each child. And he explains the difference because he thinks that the child would be less aware of the breach and so suffering less.
Right, that's that case.
Yes.
I appreciate we've subjected you to a barrage of questions, but
Yeah.
tell us what
So-
areas of your submissions you still have to cover.
So I think what I'd like to do is after lunch then just round off on the submissions, going back over the barrage, but put them in the order, if I may, that I hope to put
Okay.
slightly more.
Yes, all right. Yes.
And then I then need to turn to the judgment in the county court and
Yes.
why I say that's right, and the judgment in the high court and why I say that's
Yes.
wrong. I will then address some of the points for the defendant and its cross appeal points, and that will be my submission. So we'll get through those easily this afternoon.
Yes, well, I hope you'll be able to pass the baton over to Mr. Toman in the course of the afternoon. Don't feel any need to occupy the whole day. Right. Well, we'll break off now. 5 to 2 then.